my pleasure to introduce today Professor Dr. Manoj Kumar Sinha, the Vice-Chancellor of Dharmashastra National University, Jabalpur. He has also held prestigious positions, including the Director of Indian Law Institute and Professor of Law at the West Bengal National University of Juridical Sciences. Additionally, he is also the Vice President of the Indian Society of International Law and serves on various statutory bodies of universities. Holding a doctorate in international law from Jawaharlal University, LL.M from the University of Nottingham. He is a renowned expert in human rights, constitutional law, and international humanitarian law. Professor Sinha has made significant contributions to the field, authoring several notable books and papers. His scholarship has earned him numerous accolades, including the Great Indian Teachers Award and the recognition as one of the nation's notable bar leaders by the Bar Council of India. I would also take a moment to personally introduce Professor Sinha, who was my team when I was a student at the Indian Law Institute. Please join me as we welcome Professor Sinha.
Good morning to all the participants. And I would like to thank Professor Subramaniam, a good friend of mine and long association with sir. When I was a student of the Jawaharlal Nehru University, I remember that on many occasions, Professor Anand and Professor Rahmatullah Khan spoke about you, and I believe those days you were working in Bahrain. So he said here with Professor M.K. Nawaz. And then I had an opportunity to meet you in Bangalore when you returned back. And since then, you ensured that whatever capacity, whatever way you had an opportunity, you have an opportunity, you engaged me in journal, your coursework, and other things. So it's a great honor for me whenever I receive a call from you regarding any academic activities. So thank you very much, sir. Let me start with the topic which I have been asked to discuss today on a very important subjects which were not considered very important in 3 to 4 decades back. Like, no, I remember nobody taught us legal research methodology. Nobody thought about the hypothesis, qualitative, quantitative. It's more we started with our journey on our own. So how we started? We started with finding an area like, which we said it has not been explored adequately, or even if explored adequately, it has not been answered appropriately, or it has some scope to do research. So our research, and that remains very important today. So a generation which did not get a chance to expose to the methodology, research method, quantitative, qualitative type of research methods, research questions. These questions were not there. But as a researcher, we were able to identify. So as a researcher, what is important for you also to identify the area which you want to work. And while identifying, you have a challenge, and challenge is immense because many times you feel that already work has been done by the many scholars. And when you go to your teachers or supervisor, they say that already work has been done. So a researcher has to identify a work where some kind of a scope exists, and the work has been, of course, some work is already done. So identifying research problem becomes very important. The topic which I chose to speak today, it's more on the interdisciplinary approach. And interdisciplinary approach, which I'll discuss with you in a few minutes. But I feel when we talk about the research methodology, the most important source, which many of you may agree, exists under the Constitution, under the Indian Constitution. What I mean, if you look into the Part 4A of the Constitution, Part 4A of the Constitution, and which some way talks about the research and what kind of research and what kind of a mindset a researcher should have. So if you look into the tool, in fact, all are basically some way linked with the research, protection of environment, cultural heritage. So all are there, but too specific if I look into 51AH and 51AI. If you look into the fundamental duties of the Constitution, which gives you an idea, and that is very important. The first 51AH clearly says, which we keep on talking about, the scientific temper. The scientific temper, to develop the scientific temper, like, means, and it says, comma, humanism and the spirit of inquiry and reform. So inquiry, like an investigation, inquiry, that is very integral part of the research. Investigation, inquiry, systematic, exhaustive, intelligent. These are the terms as a researcher. So when we look into the our constitution, which we hardly acknowledge, under the part 4 of the constitution, which throws some light and a deep light when we look into the 51AH, and then it uses scientific temper. Scientific temper should not be understood more in the connection with the science. It's a temperaments like a, so you evidence-based research, evidence-based, like, you calculate, you are not concluding merely, and which is very much integral part, evidence-based research. So in the legal research, we are not talking about the evidence-based. What is the, like, evidence? You have to prove a particular point. If, like, access to justice is not there, what are the point you have in your hand to prove? So evidence-based legal research, and that is also evidence-based legal research is also reflected under national education policy, evidence-based research, legal research. So many people have no idea what is evidence-based. So evidence, the way we calculate, so means like, a firm, a conclusive or something like, you have to support your argument, evidence-based research. So like if you go back and the constitution, what we say scientific temper means a, like, a more some way to question and prove the theory, to prove the thesis, this is there, and then you support your argument, whatever point you have. And this, if you will look into the 51AH, which talks about scientific temper, which talks about humanism, which talks about spirit of inquiry and reform. So research is also knowledge building. It can also be a reformative agenda. These are the things which are there. Uh, the second, which I say, which has very much closeness to the research or objective of research. The first, the method of research, scientific temper, inquiry, humanism, and reform. That method of research you have got from the Article 51AH of the Constitution. 51AI, which talks about the objective of research. What is the objective of the research? Why you want to do something for the... So like the objective of research generally in the class, you are going to add in the existing knowledge, knowledge building. Research is also a knowledge building. Like, you contribute and you support the knowledge building. Through the research, you are supplementing an existing research that is there. So if a careful study of 51AI, it says to strive towards excellence in all spheres of individual and collective activity. So excellence, like it talks about we all are working towards the excellence, betterment of the society individually. So whatever research you do, it's individually, and it also affects the society, betterment of the society, excellence in the reform in the society, like, child rights, women rights, and others areas. If you see, that a continuously reform is taking place, excellence, it affects the individual and also. So the nation constantly rise to higher levels of endeavor and achievement. So two of the provisions of the Constitution, which I feel, and I like, by chance it occurred to me, I did not find anywhere, but when I started looking into, I found, oh my God, this is there already in the Constitution, which we hardly talk about the research. What is research? What kind of temperament a researcher should have? What he should do? So he should, like, if you club together 51AH and 51I, you can say these are the points we have gathered: scientific temper, humanism, spirit of inquiry, towards excellence in all spheres, towards excellence in all, whether it's a climate change, whether it's a human rights, whether it's a minority rights, everything. And for the to reach and higher levels of endeavor and achievement. Means you are also working individually as a duties, and also you are supporting the state as a kartavya, rashtra, your like duties. So you are nation building, you are doing in the through your research. With this mindset, when you go into the research, definitely you will do great work. The A few minutes I'll take the about the temper, like the scientific temper. The scientific temper, the word which was used by the Jawaharlal Nehru in his book in 1946. Jawaharlal Nehru, while in the prison, he wrote a book, The Wonder That Was India. So Jawaharlal Nehru, in his book, he wrote about the temper, like scientific temper. He emphasizes while he writing in a history book, but he talked about the inquiry, investigation, and he used the term scientific temper in 1946 in his book, and that has been referred in his book about the scientific temper, how things have to be. Even he's doing something on the research there. All right. Now, second point which I have. So this is the mindset of the researcher, how researcher has to prepare himself, how he has to progress himself. That we have, what are the objective of research? Some way from the constitutional perspective, we got under the fundamental duties from the 51EH and 51I. We leave it there and we move to the second stage that is equally important. When we talk about the research, and there I'm going to discuss about many things today, um, we tend to ignore the research is not solely monopoly of all of us, like sitting in the classroom and teaching here. So it's not only the uh, um, monopoly of us. There are many people equally doing the great research. And who are doing the great research? The lawyers are doing great research. Judges are doing great research. Academicians, of course, academician, we proclaim that we are the sole authority of doing the research because we have a skill, we have been taught, so we have a monopoly over the research. But that may not be true because judges equally do the research on the basis of the plaint which, brief which is given to by the plaintiff and defendant. So he also looks into non-governmental organization and of course academician and students. So we see a wide number of individuals in a various capacities. They are equally doing the research. And government does a lot of research. Government in sponsor the research is there. So research is there. And there we'll find how interdisciplinary. So the research which I have mentioned about the judges and others, well, how interdisciplinary approach is important will come into little bit later in few minutes. Uh, Today, so many of you are we all are, you all are young and you have a number of years to go. What should be the basis of the research? What government or university grants commission or educational institutions are looking for? The research, we can continue with the traditional mode of the research. Are we supposed to incorporate some new ideas, new thinking in the existing methodology of research or existing methods of research and make some element of newness, some element of uh, new ideas should be there. So any attempt, whether it's a research or teaching, and I suggest all the teachers, okay, we must spend some time on the national education policy. National education policy is a document. And what we have been informed and what we have been told, the national education policy doesn't cover law, legal education, and medical education. So it kept legal education and medical education out of purview of the national education policy. This kind of statement has created an environment. We may not find any ideas in the national education policy. If I'm a law teacher, if I'm a teaching legal study, so why should I devote time in the national education policy and find out what is there? So we believe that national education policy for the humanities, for traditional universities, social science and other. But we have to, we have many things. We have to remember national education policy aims towards reform in education by the universities, So university is important. So even a bar council recognize your law school, you cannot give a degree unless you are affiliated by the university or you are a university yourself. So university becomes the first, then comes to the affiliation, and then comes to the bar council of India. So if I go by this logic, we say university remains a very relevant actor in our legal education. It's not like it because bar council, please. Bar council comes in the third stage. Bar council start inspecting a law school when it receives an information that such and such a law school has been affiliated by the Karnataka State Law University, and then you go. So affiliation becomes first condition for starting the inspection. So let's go back because we have limited time. I'm not many things to share. So we go. So I feel the national education policy for as a researcher, we must go into the read in the national education policy. That are 20 pages. I'm sure because it talks about the primary education, higher education, and others. So the higher education part you have to read, and maybe some kind of introduction is relevant. So you don't need to read many things in there. And what it says about national education policy, many times you might have heard that national education policy we speak, uh, but we are not sure whether sustainable development. So we talk about the sustainable development goals, and particularly Subramaniam sir, international law teachers, they talk about the sustainable development goals. But sustainable development goals also gives a direction to the states, like any states, how you have to do. So one of the goals, so that I brought sustainable development goals out of blue all of a sudden, because it's reflected under the national education policy. In a very introductory note in the sustainable development goals, so it says, and it talks about that like the education, today's education. So that is why national education policy becomes important. It says the global education development and agenda. So like what we are teaching, it should be globally competitive. That you have to think about. Your research should be also not isolated in the, of course it may have Indian perspective, but it cannot be done completely looking into the domestic perspective. Today's research has, of course, some bearing of international elements, that international organization, international treaties, regional treaties, comparative perspective, some kind of overlapping you will find in today's research, whatever area you choose, even in the Indian Constitution. And that is uh, hugely reflected in the judgments. I'm like many times I see the climate change. When Supreme Court gives a judgment on climate change, court is not supposed to go and see that what Inter-American Court of Human Rights or Inter-American Commission of Human Rights is. Court is not supposed to look into the European Court of Human Rights. But judgments, you'll find the reflection of various instruments. So what they want to say, they want to say also, so they what the court court wants to uh, develop a ratio. They look into the supporting documents, evidences, and they say in the like how global framework is developing, and then they take the help of their own domestic law. So reflection of international instruments, reflections of the international institution, judgments of the various courts, domestic courts, as well as the regional courts are very much integral part of there. Why judges are doing all these things? They think that it has a value, a climate change. So you can outrightly say, climate change decisions should be based on the Article 21, 48, and 51G or AG of the Constitution. Why should we are going, and then MC Mehta cases are, series of cases are there. So you question that, but the judge, that is the reason I said the judge also do the research and they reflect something. So today's education is a global education. The development of, we have the national education policy talks about the global development agenda. Education is not solely confined. So we have to compete. Our students, a large number of students are going Australia, New Zealand, England, and United States. It was unthinkable. 20 years back, only your higher study you go. But today, after schooling, everybody wants to go and see. When they know that in England, they will not read Indian constitution and others, but they want their understanding of law will become different. So parents are also putting a lot of money to go abroad, learn something, exposure. So our research is also going to be exposed globally, and that idea we have to see. So in the national education policy, in the sustainable development goal 4, which says it, so what sustainable development goal for us, SDG 4 becomes important when we talk about the education. And we have to imbibe what SDG speaks about. We have to imbibe in our research. And it says, seeks to ensure inclusive and equitably quality education and promote lifelong learning opportunities for all. So some way it's an inclusive lifelong learning. So we leave it there. That is the reflection of there. Uh, there are one paragraph which is important and which brings us to believe that national education policy is equally important for the legal education. Of course, it's not maybe very important for the regulating bodies, but it has very important for a teachers because it focuses on a point which we need to ponder over, which we need to examine, which we need to follow in our day-to-day activities. As I said, what you are doing, it's a global framework you are working and research in a global framework you are doing. So the paragraph 20.4 and page number 50, National Education Policy. So I'm just see, so you don't need to go or like, if you don't have time, you can go directly to the 20.4 para in the page number 50 of the National Education Policy 2020. So if you read page number 50, 20.4, the point which I have been trying to convince you, the point I am trying to highlight can be noted by looking simply on the one paragraph, that is 20.4 paragraph of page number 50 of the National Education Policy. It gives a broad idea. It has so one paragraph where we have essence of legal education, the thrust of legal education, and that should shape our legal research in coming days in that particular thing. It says, and it strengthens the argument which I took a little bit early. It says that legal education needs to be competitive globally. The very first word, legal education needs to be competitive globally. So as a teacher, as a researcher, we have a huge obligation that our students, our young students should be trained in a manner where they can compete not only locally, they can compete globally and regionally. We have to develop their skill. Our writing should also be there in a manner which should be taken note of the domestic perspective and also the international scholar also look for our writings are there. So research and teaching, let's club together research and teaching to be competitive globally. It cannot be an isolated ki Karnataka, if you are sitting in Karnataka, you look. But you have to create a knowledge bank, or you have to create a human being who is well equipped to deal with the situation, whether it's arbitration, whether it's a international criminal law, whether it's environment, climate change, domestic perspective, constitutional perspective. He can look into the Constitution of India. He can understand the Constitution of South Africa when it comes to the transformative constitutionalism. He can look into the Brazil constitution. He can look into the Argentinian constitution. So constitutional perspective, you get a comparative perspective on very way. You can't see only on the Indian perspective. You look into it. So I'm saying that legal education, legal teaching, legal research needs to be competitive. So as a good researcher, he or she has to look into, and it says adopting best practices. So sometimes you question, why should I do? Because you get something best practices. When you make a suggestion in your study, you struggle what to say. Then you say these are the best practices working well in the different jurisdiction that needs to be local there. And then of course the objective of legal education for justice. like, when we talk about for the delivering justice is important. It also talks about the constitutional values, and constitutional values for the that includes social, economic, political, national reconstruction, rule of law, human rights, democracy, so on and so forth. So one paragraph 20.4 gives you more or less a complete idea what you have to do and how you have to proceed. So first, like, say, so I gave you an idea how we thinking. Thinking is an important. When you start a research, you have to think, you have to, like, devote much time, and you can always, like, it's a continuous process. You can reform. The two things, one, research is a obtain a degree for promotion, कि एक डिग्री मिल जाएगा, प्रमोशन हो जाएगा, PhD हो जाएगी. So this is one. The second, degree, of course, promotion is like, you will get, you are a teacher, you will get promotion, but same times you are adding an existing knowledge, your knowledge building, that is also very important. So when you look into all these things, when it comes to you as a researcher, then it's become very important. You have to do a great research, great work is there. uh, Even in the traditional Indian like, writings, in the in a book where Banbata in Kadambari, he talked about in even the ancient. So now I'm coming to the uh, interdisciplinary approach in the research, in the legal research, interdisciplinary approach in the legal research. So if you look into the interdisciplinary approach, this is the Indian thought process, knowledge building. When we talk about the institutional building, like, the interdisciplinary approach, which exists in the Indian uh, ethos, Indian values. So, like, interdisciplinary approach, multidisciplinary approach, it's a very much integral part of our culture. It's very much integral part of our ethos, our values that exist there. And what we are doing, if I say the ancient statement or belief, the pursuit of knowledge, what we say knowledge, gyan, the pursuit of knowledge. Gyan means wisdom. So the knowledge, it takes you to the wisdom, pragya, and truth, to find out truth. The pursuit of knowledge, wisdom, and truth was always considered. The pursuit of knowledge, wisdom, and truth was always considered in Indian thought and the philosophy as the human goal, as the highest human goal. So pursuit of the, like, knowledge, wisdom, and truth, search for the truth, search the wisdom, it was a very much part or integral part of the Indian thought and philosophy of the high, that was considered human goal. So, like, it's not a new phenomena we have learned, is there. The multidisciplinary approach, and then I come to the interdisciplinary approach. The multidisciplinary approach, when we speak about the multidisciplinary approach, what we see, even in the ancient India, it's not a new phenomena or Europeans development of the Europeans, is there the multidisciplinary, interdisciplinary approach. When we look into the multidisciplinary approach, we look into the ancient Indian like, literary works, ancient Indian literary works, and that is the such as Banbhat, which I have mentioned. Banbhat, in his writings in Kadambari, Banbhat in Kadambari, described he described a good education as a knowledge of the 64 kalas. So he spoke about Banbhat in Kadambari. He said good knowledge is the, like, this guy good education as knowledge of the 64 kalas or arts, and among these 64 were not only subject, it's not only this, like, Banvat talked about the singing and painting, but also scientific field such as a chemistry and mathematics and vocational is there. So the emphasis, the support of multidisciplinary approach was, as I said, which I have been saying, the integral part of our Indian values, and that is reflected. Let's take an example. What is there any distinction built in between the multidisciplinary approach and interdisciplinary approach? Uh, Let me finish. So when we talk about the, like, no, if you take a climate change and a issue, and in a room, if five of like, different streams people, if like, one scientist is there, one political scientist is there, one historians are there, and one lawyer is there. So like different people belonging to different streams discussing about the climate change or discussing about the human rights or any issue, they all have their own perspective. They all have their own perspective about dealing with any issues related with. They are there to discuss, but they have independent views and they carry independently. They don't integrate. They don't integrate. After coming into close, we have. So they are looking to resolve. They are looking to find out solution to an existing problem in their own perspective, and that is the looking into the multidisciplinary approach. So many times we see, but it doesn't talk about the integration. It's a like, it's an integration. It's not talking about the integration is there, the multidisciplinary approach. So like people will have different approach, like, tribal people, indigenous people, anthropology people will have different, sociology will be, history will be different. There are multidisciplinary. When interdisciplinary approach, which is very important, and why I'm saying that interdisciplinary approach, and that is going to integration of the approach on the what. So legal approach is the sociology of law, like what we solving the problems more on the social perspective, sociology of law, what the law is an instrument of social change. Ehrlich and Roscoe Pond both spoke about in 1910 and 1913 about the sociology of law. They thought about, the law should be integrated, the social perspective, social conditions are there. And many issues when it comes to the family law, particularly in India, it's a statutory is there, and you have also their own practices, family laws, customary practices, what they believe they continue to do that, or their own religion, their own practice, whether it's a Hindu or Christian or any other religion they follow on that one. So family law, many matters, it governs through the both the statutory or customary practices in in a there. So some way, uh, it's integrated. It's not only on that particular, like, only statutory or constitutional way. It looks into the different perspective. So integration is important. Interdisciplinary approach, law should not be seen in isolation. And that can be again understood very clearly. And I'll suggest and I'll encourage that paper is also available, legal research by Dworkin. Dworkin wrote a paper on the legal research long time back, on the legal research in the, and there Dworkin compared two systems. The Dworkin compared two systems. One, the systems, legal education uh, being addressed, legal education being understood in the United States of America, and legal education understood, taught, and followed in the UK. So legal research article, which long time back Dworkin wrote, he compared two systems, that United States of America and UK system. And that is like, that gives us a very good idea. So both, like, interdisciplinary and monodisciplinary, interdisciplinary and monodisciplinary. So what he said, the law education, and I think we also know that what he said long time in the United States of America, which continues till date, the legal education is part of the social science department, humanities. It's a integrated. So law is also like history, sociology, economics, political science, and law. Here, like we have different. So he says it's a part of humanity. So Americans, they looked into the more as a integrated, interrelated, interdependent, some way political science, law, history, sociology, economics. So many subjects are and it's a part of the humanity. Whereas when he compared in the United Kingdom, he said in the UK system, it's more focused, more concerned on the principles, doctrine, judgment, precedents. In all these things are important when it comes to the law education. And he said, ki, we don't need to, the legal scholars in the UK, they focus on the precedent, they focus on the principles, they focus on the theory, they focus, means the way we look into the legal education, we think about the, not interdisciplinary, we are trained. When we talk about, when you write something, a teacher will immediately say, where is law? You are writing something, it's a political scientist. So you may face a response, a reply sarcastically, where is the law? Means we understand law means judicial decision. A chapter has to be judicial decision. With law means statutory framework. What are the national legal framework is there? What are the legal theories are there? And then conclusion. Then it means you have done some great work on the any chosen topic. That is the way we look at it. Means our domain, our areas of functioning is a library based. You go and study the doctrine, you go and study the theory, you look into the decisions, you look into the what happened and what will happen. That's like, already you go into back. If legal research, what we are doing, things already decided. It's an ex post facto research. Somewhere things already decided. If you are writing basic structure doctrine means what has been said in the 1973 and how it's going, and then subsequent conflicts you uh, keep on keep on changing or like but your journey starts with what happened and what will happen on the prediction of there. So what the model which we have been following for ages in India is more or less the system which is very much prevalent and common in the UK system, a monodisciplinary approach is there. But today time has come to think about the interdisciplinary. If law like applied research or action research, like effectiveness. If you look into the Department of Justice, the website of Ministry of Law and Justice, and particularly Department of Justice, they have series of research. They also allot research topics to the various university and colleges. So what they are doing, they have given action research in law. The topic, the theme, broad theme is there, action research in law. So action research kya hai? Action research means you suggest ki how effectiveness of law, whether law is effective, what are the measures, means you go more on the empirical mode of research, how you will understand if access to justice, if I have to answer access to justice and says ki no, then as a law teacher, I will go into the constitution and say article 39A, it talks about criminal law, also talks about, and then also I can uh, Legal Services Authorities Act 1987. So access to justice means my journey ends there. This is access to justice has reached to the doorsteps of the poor people or not, that you have to look at. Then you find when there's a disconnect between what law exists and what law uh, in practice at the ground level. You find there's a huge gap. People have no idea. People have no idea what we are talking about. People have no idea what we speak. So it's always good and nice when you give a mic to a teacher, a judge, and everything, talking about big ideas, big theory. That everybody will say, we have to be more patriarchal, has to finish. We have to be more accommodative. There's a lot of things. But just if the same premises. So these words are more in a elitist kind of concept where we talk about the privacy, where we talk about the access to justice. So these have become a very like in a filmy kind of scholar. So we are a scholar where we speak about the dialogues, ki kya affirmative action, this, that. But when you come to the practice, you find just 100 meters away from same the dice, the person who is serving food or service, doing, how they are being treated, how you feel offended. When a person of the, a person who just supposed to arrange dice comes close to you, you feel offended. So you talk about the equality, but equality, it's a intersectional, gaps are there. Different layers of inequality exist in this society. If you are in a car, your driver comes and sit next to you or eat with the same table he sits. So even a judge of Supreme Court or even a professor of the university will feel offended. I can't sit with that particular person. We giving a lecture of affirmative action, but we make a distinction. There are distinction because of economic status. There is a distinction between the color, distinct position. So a lot of level of distinct discrimination exists. It cannot be changed, which are unthinkable. So when you land in the European states, you may be surprised. A cook is sitting with the vice-chancellor. A sweeper in the morning who cleans. And this is the truth. I'm telling you. This is the truth which I have witnessed myself. When I landed in the Sweden, I saw a elderly lady, and it was more or less in the way. And these are the things we have to learn if you want to eliminate the discrimination in society. So a lady early morning, she used to clean toilets in the all the building completely. And after some time, we had a party in the Christmas party in the evening, and that was the shock of my life. I've never thought this can ever think about in India. In the evening, she also joined in the party with everything, and director of the institute talking to her in a so friendly manner. I was totally surprised. This is the level of the equality. Here the equality is it exists in the paper, it exists in the our discussion, but in practice we are different and we want to remain different because our economic status doesn't permit. So these are the research, these nuances in the research. This idea of discrimination will not end only with the judgment of the Supreme Court. Empowerment of women will not come only with the Babita Punia and other cases, Visakha judgment or everything. It has to be a culture where everybody aspire for the ending. It's not the judicial decision will end or solve these problems. These problems will remain. So a researcher has to understood, and that is the reason interdisciplinary approach is important. A judge will speak about the court decisions. He says, I'm proud of saying something. I'm proud of the Supreme Court. But that is not the ground real. The judgments are individual centric. And even individual-centric judgments are overturned. If you go back to the Savano judgment and number of judgments, it's an individual. You can't enlarge the application. It's not happening the way it should have been happened. So you try. So if the banning of the triple talaq is become an issue, Saira Bano judgment also gave by the judges. But whether it has completely stopped, the practice continues. How many women wants to go? If something happened wrong to a woman, there are many cases. They don't go and complain because they don't have a faith on the police. They don't have the faith in the enforcement system. And I had a student who she was a public prosecutor, and she said many cases where the victims of sexual assault after 3 to 4 years they decided to withdraw. They decided that I am not want to continue, finish the case because the procedure, they said unnecessary taking time. So many cases prolonged. So so one has to correlate. A researcher has to correlate with the ground realities, and that is the reason I said application of law is equally important. How it reaches to the trickles down to the ground level. And that approach is possible only when you move from the traditional way of the research from doctrinal to little bit on the empirical research, field-based research. So I say interdisciplinary approach where how it's going to affect, you have to come out from your cell and you have to go in the field to find out, and then your understanding will be what I'm speaking about. You will be more effectively say, these are the changes there. If Andre Vete, Desai, and M.N. Srinivas, they wrote sociology books, they wrote the sociology books by living in the society. They become part of the society. They stayed in the society for many months together, and then they wrote a book. So their perception and understanding is much higher and much bigger is there. Let's take some of the cases. How court also is very important. Now, when we talk about the cases, we always talk about the judgments of the Supreme Court. We tend to forget about the uh, judgments delivered by the High Court. And I'm just missing the name of the judgment, but a judgment which was delivered, how could judge has looked into the interdisciplinary approach. And this is the case related with the, uh, a decision was delivered by the Meghalaya High Court in 2018. And the facts of the case was related with more than a domicile issue. I think Union of India versus or state of Meghalaya, Anup or something in the. I remember the name of the judge. I'm not able to locate the judgment case right now. Justice Sen authored judgment in 2018 on 10 December 2018. I remember the date. I'm missing the name of the case. So this case is very interesting. The facts of the case: the person who has been living in the Meghalaya state of Meghalaya for many years, and he secured a government job. So after securing a government job, he was asked to give a domicile certificate. He said, you produce your domicile certificate. He was not born, and he born there, but he from migrated parents. So like they migrated from there, and then history becomes very important. So issue court could have done. So suppose a teacher. So this is the issue. Court could have easily given a direction to the government to issue domicile certificate if he meets the eligibility condition. This is the issue. But Justice Sen looked into beyond, and he said why we had such kind of problem where law is quite clear. Law is quite clear because if you are a habitual resident of a particular place, somewhere 5 years, 10 years, or the conditions, if you are natural born, there are a lot of things are there which are in favor. It's not very difficult to decide about domicility of an individual. But court looked into different. And in that case, I came to know something new, which even I had no idea. We always talk about the integration of Jammu and Kashmir, Hyderabad, Junagadh, or many states. We talked about how these states have been integrated in India after the time of independence. We never talked about the referendum which actually took place. In Jammu and Kashmir, we have talked about referendum. But referendum was the ground to decide whether that province of the India will be undivided India will be part of India or East Pakistan. So referendum, I'm talking about the referendum of Sylhet in the Assam, Sylhet. Sylhet is the province which was dominated by the Hindu communities. They were dominated in the Assam also in the bureaucracy and other. So Sylhet referendum had implication of this kind of problem in Assam is there. In Assam and other northeastern states, it's not only the Hindu and Muslim, it's also the Bengalis and the local. It's a Bengalis. So a large number of Bengalis from East Pakistan, they moved and they were there before also. They were very much part of there. So Bengalis people were living in the and they are still living in the number of the Eastern India. So what the judge has done. So I say, to come to the point, what judge has said in this interdisciplinary approach, he had said the entire root cause is the history, the partition. Whether it may be right or wrong, we don't need to go. So the root cause is the partition of India. And partition, he said, how government of India and how government of Assam have ignored the Sylhet referendum. They did not bother too much about the Sylhet referendum. And then outcome, the Sylhet has gone to the East Pakistan because lack of interest to pursue vigorously and ensure that a referendum takes place fairly in 1946 was missing, 1947 was missing, and that is resulted there. And he quoted 2, 3 books, history books, in a judgment. So I'm saying why then he mentioned about the books, historical books in that particular judgment. And then he comes to the law. But he in the entire 38 pages judgment is more history, more like ancient practices, more about the refugees, and then less about the domicile, which he said his entitled should be given in the end of the judgment. So facts of the case. But he looked in a larger, route, whether the judgment, whether the domicile certificate has benefited the candidate or not. But certainly it has been, judgment has benefited to change my perspective. And I start thinking about how a judge can also look into the larger perspective, a domestic perspective in a when it comes to the uh, uh, looking into the issue, and that is important. And that very, I'll take one more case and then I'll close here in the uh, how a judge attempts, and that is the judge also thinks, and we have to also think. So a judge thought about, he linked number of factors, refugee, partition, and then he decided domicile matter. He did not decide domicile matter on the conditions laid by the government of Meghalaya. It looked into the different perspective and given a new perspective. The last part which I want to mention before you is related with a very important judgment, and that but we hardly know, and maybe some of you may be aware or not, I'm not sure. That is the Nomgyal Dolgar, Nomgyal, Nomgyal Dolgar versus Ministry of External Affairs. This case was decided by the High Court of Delhi. There are a series of cases where High Court of Delhi has given landmark judgment. So in the High Court of Delhi, this case pertains to a request of a Tibetan born, like a Tibetan girl who born in India on 13th April 1987. She born in the 13th April 1987 in India, and she applied for the passport. In as a interesting part, the Tibetans in India, they have, each Tibetans have a identity number. They don't acquire the Indian citizenship. They have identity number. On the basis of identity number, their travel documents, passport, and other things. Because Tibetans believe from the day 1959 till date, one day they will go back to the Tibet. So they say it's a Tibet government in exile. Dharmashastra, we say Tibet government in exile. So they believe on that one. Anyway, this girl applied for the visa, passport, and she quickly mentioned about the Indian citizenship. So citizenship issue is there. So she mentioned by birth she's an Indian citizen. Passport office denied because passport office said, look, you are Indian, no doubt about that, but you have not filled a proper column. Your column is there. You put your identity number, we'll issue the passport. She refused to do so. She said, no, I am Indian and my birth has taken place. Finally, she went to the High Court. High Court not looked into the what kind of arrangement we have into the with the government of India and Tibetans, what are the different steps taken by the Ministry of External Affairs, Ministry of Home Affairs when it comes to the Tibetan. Court simply looked into the Citizenship Act 1987. That time in 1987. Court did not go into all these things, legal aspect. Court looked into the Citizenship Act, and Citizenship Act, the time the petition was filed, it says anyone can acquire Indian citizenship if birth takes place in India, irrespective of the parent status, whether parents are legal, illegal. These questions were not there. So legality of parent status become important after this judgment. And court interpreted the Citizenship Act and said, she is a Tibetan citizen, she is an Indian citizen because she has born and she is entitled for both. If she wants to fill Tibetan identity, fine. If she wants to the Citizenship Act, Indian citizen, that is also fine. And directed the Ministry of External Affairs to issue the passport. And this is the case. which also opened the door, which was decided by the Karnataka High Court in the 2013 for giving the first time permission for the 30,000 Tibetans to vote in the general election. The first time in India, Tibetans voted. But that was possible because of Karnataka High Court judgment, which was delivered. I think I'll close here by saying that, a holistic approach we need to see. We can't continue with the same way what we have been doing, going in the library, searching in the judgment, and then you come to the conclusion on the basis of what court had said, what court should have been said. But you have to see how the effectiveness of the judgment, where torture has been stopped, where access to justice is there, where the rule of law is there. You have to correlate with the ground reality. You have to look into the why it is not happening. You have to see the relationship between law and sociology. You have to see in the relationship between the law and history and economics, law and economics, when it comes to the WTO and trade. So you have to examine an interdisciplinary approach. Interdisciplinary approach allows you, permits you to integrate the approach. It's not like multidisciplinary. So you can integration is possible, and that is there. So as a young scholar, young teachers, I suggest you move on that direction, and I'm sure time has come to take the research seriously and go according to the interdisciplinary approach for our work. With this, I come to the conclusion by thanking Honorable Professor Subramaniam and all of you for giving the time and for sharing my thought with all of you. Thank you very much.
We thank you, sir, for your thank you so much, sir, for your insightful session and for taking out the time to address us.